Hello and welcome to part 2 of this two-part CPD cast series on competition law compliance, in which I'm still joined by Sophie Lawrance from Bristows. Okay, so Sophie, if we can continue from where we left off in part 1 of this CPD cast series, where we were looking at penalties that can be enforced for infringement of competition law by companies and in particular at the fines that can be imposed. Are there any other penalties regulators can enforce?
Regulators, as well as fining, they can also order companies to change their behaviour in future, so effectively regulate their future conduct by issuing orders. And an example of that would be the Microsoft case, where Microsoft was ordered in 2004 to give access to certain interface information to other Windows Media Player producers so that they could interface with the Windows operating system. And Microsoft was ordered to make that information available on fair and reasonable terms. And that in itself was something which then gave rise to further disputes and further fines on Microsoft for non-compliance. I've also mentioned the penalty of director disqualification very briefly. This is a power that's specific to the UK, and if it's granted, it disqualifies a director from running any company. So it's not just that it disqualifies the director from running that company, it's a suspension over a number of years of the director from having any managerial involvement in a company. And it's important to note that there's no requirement that the director was actually actively involved in the infringement. The standard which is applied is an ought to have known standard, meaning that ignorance is no defence. And this is just sort of drives home the point I was making before about the fact that management, senior managers and directors do need to buy into their competition law compliance programme, because the directors at least face personal risks if they don't do so. Having said all that, it is worth, however, noting that so far no director disqualification orders have been made, which is somewhat surprising because it was a power that the OFT was very pleased to have. And I think there's been sort of encouragement that the power should be used more in future. So we'll see what happens.
Turning to private enforcement, can you tell me more about the situations in which agreements might be void and other companies might claim damages?
Companies can't enforce contractual provisions which infringe competition law, and that can even lead to an entire agreement being void. And that's a sort of everyday practical consequence of including anti-competitive terms in an agreement. The last thing a company wants when it's spent a lot of money on negotiating a contract and there's a lot of money riding on the contract itself is to find that it can't enforce the contract. Examples of contractual provisions which competition law may render unenforceable depending on the circumstances include minimum price agreements, prohibitions on selling outside a particular territory, non-compete agreements, certain exclusive dealing requirements, or requirements to exchange commercially sensitive information. On the damages side, so civil claims for damages, the European Commission in particular is very keen to enforce private actions for damages because it believes that they enhance enforcement efforts while actually kind of creating some compensation for the companies which has been affected by the breaches. The European Commission published a white paper in 2008 about this, and then much more recently this year it has published a draft directive aiming to harmonise the rules of member states to ensure that effective redress is available for those who have been affected by anti-competitive behaviour. Two types of private enforcement are available. One is a follow-on action where an infringement finding has been reached and companies or consumers who've been affected by the infringement can then claim damages without having to reprove the infringement. There are also standalone actions where a company is simply sued for having breached the competition rules. The UK government is also very involved in this area and has recently consulted on changes to the competition law regime which would make it possible for consumer groups to bring concerted actions more easily. And well, it's not just being consulted on, it's going to be implemented is a opt-out regime, so that if a representative body brings a claim against a company for having breached the competition rules and claims damages as a result of that, then anyone who would benefit from that, who has been damaged, is part of the group of types of consumer who've been damaged, will automatically get a share in the damages which are payable unless they specifically opt out.
So it certainly sounds as if there are a lot of good reasons for avoiding breach of competition law, Sophie. Do the competition authorities take into account whether or not a company has a competition compliance policy when deciding whether to fine them?
Yes, there are certainly a lot of good reasons for having a competition law compliance programme, and if it's successful, it can prevent serious anti-competitive conduct being carried out and therefore avoid high fines and serious reputational damage. However, it has to be said that the competition authorities don't generally give any credit to companies for operating a compliance programme. In fact, there has been in the past some suggestion that a company which breaches competition law, even though it had a compliance programme, should receive higher fines because it obviously wasn't abiding by its compliance programme effectively. But I think the competition authorities have realised that that would disincentivise the creation of compliance programmes in the first place. The RFT is a bit more flexible in this area than the European Commission, and it has acknowledged that a robust compliance programme might be a basis for a small reduction in fines in some cases. But in practice, you don't see these reductions very often. If you look, for example, at the RFT's decision in Hasbro, a cartel case in the toys and games sector, a compliance programme had been in existence in that place and it was referred to, but the RFT refused to give any credit for that compliance programme because it had been flouted by the senior management who were directly involved in the cartel. However, it's theoretically possible that if an infringement was committed by more junior staff without the knowledge of the senior staff and in contravention of a properly enforced compliance programme, as I say, it's possible in those circumstances that the RFT would view that favourably and would therefore reduce the fine for the company.
How can companies achieve a proportionate approach to compliance while still achieving business goals?
So the first step would be to identify the most relevant risks to the sector. So, for example, a company with significant market position, a strong market position, would need to consider whether its actions could amount to an abuse of dominance, while for a smaller player those concerns are not going to be so relevant. Companies need to effectively strike a balance between their desire to compete and to innovate, all of which are obviously very positive things, and their attitude to risk. So that means the risk of breaching the competition rules. They need to take an intelligent approach. Not every agreement which could infringe the competition rules carries the same substantive risks. More minor infringements, so you might think about, for example, a refusal to, or a requirement to grant back IP rights, for example, that would really count as a more minor infringement of the competition rules, and those sorts of infringements are only rarely going to be of interest to the public authorities. And it may well be that the only risk of including a term of that kind is going to be as to their enforceability. So in that context, it may well be that a company will be content to include some provisions in an agreement, even though they may ultimately be found to be unenforceable. A company may similarly be prepared to risk an adverse finding by an authority for something that it views as commercially vital to its business, especially if they have taken the view that on the basis of established law they actually have very good chances of defending their position. But as I've mentioned, regardless of the substantive risks of an infringement finding, which can be difficult to determine up front, the risks associated with an investigation, including the potential reputational damage associated with that and the diversion of management time, are very significant in themselves. And that's something which needs to be taken into account when building a compliance programme.
So, Sophie, you're suggesting that a risk-based approach is the right one. Does this have any support from the competition authorities themselves?
Yes, it does. The UK's RFT has published guidelines which set out precisely that, a risk-based approach to compliance. And the RFT's model has 4 aspects. It has, firstly, risk identification. So that's looking at the potential risk areas for the business and by reference to the industry sector that it's in. Risk assessment, how those risks that have been identified can be quantified. Risk mitigation, so that's where compliance training comes in, and also strategic decisions as to how the company is going to operate its business. And finally, review, so regular review of these aspects to ensure that compliance is maintained. And the RFT points out that extra reviews may be needed, for example, if the company acquires a new business or if there's other significant change in the market. And the RFT also emphasises this top-down approach that we've been talking about, so that's ensuring the buy-in of senior management.
What is the best approach to ensuring competition law compliance in practice then?
So we've talked a lot about the risks and the overall reasons for having compliance programmes. So in practice, what is really needed is a tailored compliance programme. A set of written materials is the usual place to start, but as I say, it does need to be tailored. An off-the-shelf package isn't going to highlight the risk flashpoints in a particular industry as effectively as specific training. So a written compliance manual should be backed up by actual interactive training, and it also needs to be monitored so as to ensure that it is effective. Companies should try to make sure that their compliance manuals are useful, practical documents, and this can be achieved, for example, by including actual examples of acceptable and unacceptable behaviour, lists of do's and don'ts, and so the do's and don'ts would capture the really most significant risk areas where cartel conduct could be involved. But it's also useful to have a set of actions which would need to be referred to in-house counsel for further approval, so that companies can be aware when they're engaging in activities which could carry some level of risk. One thing that companies, particularly major companies, can find useful is benchmarking against other companies to see how they carry out their competition compliance. And some companies go so far as to publish their competition law compliance manuals on the internet, which can be useful for this. Because obviously the last thing you want is to get involved in an information exchange, an unlawful information exchange, when trying to set up a competition law compliance programme. When carrying out the training, it's obviously important to think about who the important people to focus on are. And these are the people who are going to bring the issues to the attention of the relevant people in the management and legal teams. So the training is going to need to be tailored to different groups of employees. So think about sales and marketing personnel who are in frequent contact with competitors. Think about the different sorts of interaction that senior managers and directors may have with competitors or customers. The programme needs to be regularly reviewed so that it can take account of changes in the market context and in the law. You need to be aware of when staff move within the company and when new staff are recruited, that competition law compliance is brought to their attention. And refresher training should also be offered. How regularly is really a matter for the individual company. Some companies would do it every year, some companies would maybe do it slightly less frequently. Just to sum up, it's potentially worth bearing in mind what the Organisation for Economic Cooperation and Development, that's the OECD, has said about competition law compliance. They published a paper a couple of years ago in which they were looking at competition law compliance across a number of different jurisdictions, and they boiled it down to effectively what they call the 5 C's. So they are commitment, that's a company's commitment to ensuring compliance, a culture of compliance, compliance know-how and organisation, so that's things like the manual, the training, how people actually then raise issues with their superiors, controls, so that's effectively checks and balances, and constant monitoring and improvement.
You say that the implementation of the programme should be monitored. How can companies approach this?
I think it's fair to say that a competition law compliance programme needs to have teeth if it's going to be taken seriously by employees. So once a company has a manual and a training programme in place, it may be tempting for them to think, well, that's competition law compliance covered, I don't need to do any more. But as I mentioned before, the mere existence of having a policy in itself is not going to be taken seriously by regulators as evidence of compliance or mitigation in the event that fines are being imposed. Companies need to just keep at the forefront of their minds that the reason for having the programme is to avoid infringement in the first place. There are probably a number of different ways of checking that the message is getting through to employees. So one way would be to have a mandatory test to be carried out at the end of the training sessions, or a refresher test to be completed on a yearly or biannual basis. After the training has been provided, it may also be necessary to impose sanctions for failure to follow the programme. And that could even mean dismissal in the most severe cases, so where, for example, a particular employee has initiated cartel-type discussions with a competitor or has considered doing so. Coupled with the possibility of sanctions, companies can offer more positive incentives to encourage reporting of potential issues. It's important that there's an effective internal reporting mechanism to in-house counsel or another senior manager, or potentially even to a number of different senior managers, so that employees are able to report to whoever they feel the most comfortable. Some companies make use of grace periods, particularly after a competition law compliance programme has just been introduced, to encourage any risky conduct to be reported without serious adverse consequences to the individual employees. Another thing that companies will sometimes do is to get staff to make, particularly more senior staff, to make an annual declaration of competition compliance. And that's a clear statement of the importance of compliance to the organisation. So in essence, what most companies find useful or effective is a mixture of carrots and sticks to achieve compliance.
Are there any other ways of judging how effective the programme is?
Yes, companies can also take a step back and just simply look at how how a company's behaviour, what it looks like on the market. So senior staff should think about whether their company can be seen to be genuinely behaving independently on the market. Many of the most serious competition law infringements can be avoided by asking the simple question, has my company decided on its commercial strategy by itself, or has it somehow discussed or agreed or aligned it with another company? Obviously, normal commercial agreements remain important and viable, but more illicit or informal agreements which result in some kind of alignment of conduct with a competitor are likely to be problematic. I remember with a compliance programme, the most important thing is to address the most serious infringements of competition law. So those are the cartel type conduct that we've discussed before, like price fixing, market sharing, output restrictions and bid rigging.
What are the potential flashpoints which companies will commonly encounter?
Probably the classic and most dangerous flashpoint are trade association meetings. Industry bodies and trade associations are one of the most common opportunities for competitors to meet and potentially exchange commercially sensitive information. And for that reason, the competition authorities have for some time been quite suspicious of trade associations. Now, clearly trade associations can have legitimate role to play and are not always going to be a danger point. But the case law does show that they can give rise to risks for companies. So, for example, if you look at the T-Mobile case of 2008, that showed that it wasn't actually a trade association meeting, but it showed that even a single meeting between competitors, and in that case we were talking about the mobile network operators in the Netherlands, even a single meeting between them in which sensitive commercial information was passed and passively received can be regarded as constituting a concerted practice or anti-competitive agreement. So companies which meet up with competitors do need to be extremely careful about how they deal with those meetings, and in particular how they react if they do receive commercially sensitive information. In any context where you meet with competitors, and that includes trade associations, it's prudent for a contemporaneous note to be taken of what was discussed at the meetings. A trade association meeting should be run formally, so it should have an agenda and it should have minutes being taken. But if, for any reason, you as the company participating in a trade association realise that the minutes may not effectively capture the entire meeting, then it may be sensible to take an independent note specific to the company as well. A particularly dangerous place in the context of trade association are the fringes of the meeting. So that's in the bar afterwards, in the corridor beforehand, because those are the places where 2 or 3 competitors may have an informal chat which can result in a decision to engage on a course of anti-competitive conduct, or can give rise to illicit information sharing. And there was a very recent case before the General Court of the EU which concerned the banana industry. This is the Dole food case. And that dealt with the idea of what was rather amusingly referred to as radio banana. So that's the idea of that was that it was an informal industry gossip which was quickly and widely disseminated between competitors. And the court and commission held that was unlawful and distinguished these discussions directly between competitors with the more sort of formal acquisition of information from customers or third parties who assemble the information and make it available. These sorts of informal fringe discussions can give rise to unlawful information sharing. So it's really important that employees who participate in trade associations on behalf of the company know about these risks and that training is targeted appropriately. Talking about contemporaneous justification, it's also worth bearing in mind that this can be extremely important in a company's ability to prove its position any subsequent investigation, because that's the sort of evidence that the competition authorities will take most seriously. So, for example, the recent Apple ebooks case, which was closed by the commitments in the EU but by quite a serious infringement finding in the US, showed that quite clearly, because Apple made a number of arguments which suggested that its agreements with publishers were pro-competitive, but it was unable to support its arguments by any suggestion that it had considered this rationale for the agreements at the time when it entered into them. That was also the case in the AstraZeneca decision of the Court of Justice. In that case, AstraZeneca had again said that its conduct, which had been held to be an abuse of dominance, was justifiable, but because I hadn't mentioned the arguments it was making at the time when it was carrying out the conduct, those arguments were disregarded. So we're talking there about the absence of contemporaneous justification. Conversely, any evidence which is contemporaneous of collusion or a sort of anti-competitive aim for conduct will be taken very seriously by the authorities and can transform contractual arrangements which might otherwise be justifiable into anti-competitive agreements. Another aspect to consider in terms of competition law compliance is how legal advice is taken. A lot of companies, big companies, obviously have in-house counsel. But when designing a competition compliance policy, it's very important to bear in mind the fact that for the purposes of EU competition law, communications between in-house counsel and their employers are not privileged against disclosure. That's not the case under UK law, so if it's purely an OFT investigation, then the normal rules on legal professional privilege will continue to apply. But in the EU context, the competition authorities will often, they're entitled to look at advice from in-house counsel, and they will often seek it out as being the best evidence available of a potential infringement. In-house counsel obviously still has a role to play. He or she is someone who understands the business inside out and can give practical advice about the real risks of a particular proposal. But, as I say, the advice, if written down, is going to be something that the authorities will look to. And they may even impose higher fines if the company was advised not to carry out a particular practice due to the competition law risks, but then decides to go ahead and do it anyway. One solution to that, which is not necessarily terribly practical, is to discuss the ideas orally if possible. At least a preliminary oral discussion to iron out the most risky areas could be useful. Other aspects of internal communication which need to be considered. Employees should keep in the forefront of their mind that any communication which is written down could be something that would be looked at by the competition authorities if they do have cause to investigate. So company employees should remember when they're writing things down that this is a possibility, and they should really consider whether they would be happy for what they're writing to be published more widely. So, for example, a private email between two employees in competing companies, which might have been intended as a joke, could sometimes, in a different light, have a rather different implication. Companies should also ask their employees to watch their language. So it's often not very helpful for company employees to talk a lot about things like dominating the market, or to be very definite about, we are the leader of this particular market and so on. Obviously that sort of language is quite commonly used, but it can be sometimes taken to be indicative of the company holding a dominant position. Obviously, any sort of communication can be caught. The Commission is not just coming looking for strategy documents. They will also look at email. They will look at instant messaging. They will listen to voicemails. They will look at text messages. And those are all relatively informal methods of communication, which may be quite truncated. Communication is often carried out in those forums without fully thinking through them. But really, part of the compliance training needs to emphasise that care needs to be taken when communicating through these methods, as when drafting other documents. And a good example of how dangerous things like instant messaging can be are the recent banking LIBOR infringements, because they were largely proved through the instant messaging between competitors.
You mentioned taking care with documents and record keeping. Can you tell me more about that?
Yes, as with any compliance programme, documents are going to play an important part in attesting a company's respect for or disrespect for competition law. When an investigation is underway, the consequences of destroying or tampering documents are severe and can even give rise to criminal penalties. If the guidance we've been talking about has been followed and thought has been given to compliance when creating documents, then the concerns of an investigation should be reduced. Some companies make use of document retention policies, so that really is probably often better known as a document destruction policy, because the idea is that companies encourage their employees to keep documents for a certain number of years and then to destroy them after that. And these can be useful, although it should be borne in mind that they're unlikely to conceal a serious infringement of the competition rules, because, for one thing, document retention policies are rarely 100% effective, and for another thing, even if they are effective within a particular company, if you're looking at a market sharing agreement, say, then the competitor, who is also party to the agreement, may well be holding significant parts of the evidence itself. Any email traffic goes two ways, and so there could be emails being held off-site which wouldn't be captured by a document retention policy. And as we discussed already, creating a positive contemporaneous record, which should be retained, is a very useful thing to do as well. We've talked a little bit about privilege and the problems with that. Where privilege does apply to a document, so particularly where it's advice from external counsel or where litigation privilege applies, those communications should be clearly labelled and ideally, and this is a counsel of excellence which I understand is difficult to follow in practice, but they should ideally be kept separately from other communications so that there's no inadvertent waiver of the privilege. And finally, if you are notified of an investigation, a company needs to take steps to ensure that all destruction of documents is put on hold, because an employee operating a shredding machine when the inspectors come round is likely to look like an indication of guilt, even if it's actually quite unconnected with the investigation.
What should a director or employee do if he or she thinks there has been a breach?
If an employee or director suspects that an infringement has taken place at their company, there are a number of preliminary steps to take. First, if the issue has arisen through contacts with other companies, get a factual account down in writing from all the relevant employees as soon as possible. This fits in with this idea of creating a positive contemporaneous record. If you find yourself at a meeting where you realise that collusion is taking place or risks taking place, then the most prudent course of action is simply to leave and to have your departure noted in the minutes. And then you can consider further at a later stage whether anything further needs to be done. In these sorts of situations, it may be time to get in-house counsel and ultimately external counsel involved. In the worst case, if the company really has been involved in the beginnings of anti-competitive conduct, then it may need to make a leniency application, which is something that often needs to be done with a great deal of urgency, because once one company considers making a leniency application, it may well be that another company is also considering it, so there's going to be a race to the regulator to get the evidence in first.
Finally then, competition law is not the only area in which compliance training may be needed. Is it possible to combine different compliance training?
You're right, there's a number of different areas of law apart from competition law do necessitate some form of compliance training. Examples include anti-bribery legislation and also health and safety or environmental protection legislation. It may well be appropriate to combine compliance training for some different areas, so anti-bribery rules, for example, have a number of overlaps with competition law. But ultimately, how this is handled is going to be down to the individual company's needs and the business sector in which it operates. And I would say, from a competition law perspective, what remains important is that the relevant employees and staff have an adequate understanding of competition law flashpoints and the ability to prevent those from arising.
Thank you, Sophie, for coming in and for discussing competition law compliance in this two-part CPD cast series. That concludes part 2 of this CPD cast series.